Good morning, and I'll be doing this legal issues in information management, answering questions and providing the answer. I've grouped here easy questions. Here we have easy questions, and I have also a group of questions we'll look at as difficult questions, eight difficult questions, and I think nine easy questions. So the difficult questions are the ones that require some technicalities to answer, and you know how to answer them when you come across them. Discussing legal issues in for information management. Let's start with the easy ones, the easy and short ones, the easy ones that require less technicality. First, let's start with write short notes on the following. A. Cyberspace. Cyberspace refers to the virtual environment where communication, data exchange, and interactions takes place over the internet and digital network. It encompasses websites, social media platforms, online marketplace, email, and all other online services. For example, platforms like Facebook, Google, e-commerce sites like Amazon, and they all operate in cyberspace. Relevance. The cyberspace has no physical boundaries. Please take note of this, which creates unique legal challenges, such as enforcing laws across different countries. That's where the issue of jurisdiction comes in. B. Cyberspace jurisdiction. The issue of jurisdiction comes in because cyber law jurisdiction. You see, cyber law jurisdiction refers to authority of a legal body to apply laws to activities of individuals or entities within the context of cyberspace, which means that it determines which country or region laws apply to dispute or crimes that have been committed online. The key challenge is that the key challenge is that jurisdiction in cyberspace is complex due to global nature of the internet. For instance, fraudster A might target victim B using servers located in country C. A fraudster in country A might target a victim in country B, and the servers is located in country C. Another example is where the buyer is in Nigeria, the seller is in Brazil, and the server is in the UK. This is a typical example. Example of a physical case is Yahoo LCRA case in 2000, where the French court ruled that Yahoo must block access to Nazi memorandums in France, highlighted cross-border jurisdiction issue because Nazi memorandums were being banned in France. So let's go further. Cybercrimes. Cybercrimes are illegal activities carried out using computers or digital network. These include hacking, identity theft, phishing, and stalking, cyber stalking, and spreading malware. Example: WannaCry ransom attack of 2017 encrypted files of over 150 countries and demanded Bitcoin payment. Relevance: cybercrime pose significant relevance to law enforcement due to the anonymity, the scale, and the cross-border nature. These are these three things mentioned: the anonymity, scale, and cross-border nature. These are things that must be present in cybercrime. Looking at it is let's look at excuse me, define jurisdiction with reference to legal issues. Jurisdiction refers to jurisdiction refers to legal authority of a court to legal authority of a court or government body to make decisions and enforce laws within specific geographical area and subject matter. In legal issues, that determines where the case can be tried and which law applies. There are types of jurisdiction. You see, jurisdiction can be in the matter can be territorial, personal, or subject matter based. Example, a Nigerian court has jurisdiction over case involving citizens in Nigeria, while international tribunal might handle cases involving cross-border disputes. Importance: jurisdiction empowers proper governance, legal order, and legal order, resolution of dispute without conflict between legal systems. That is just what is defined jurisdiction with reference to legal issues. So jurisdiction refers to the authority of a court or government body to make decisions and enforce law within specific geographical area and subject matter. So these are the three kind of jurisdiction that exist in matters of in matters of determining a country's jurisdiction under international law. So I'll be using one: prescriptive jurisdiction refers to a country's authority to make and apply laws to persons or activities. It allows the state to legislate and establish legal norms within its territory. So for its nationals or for its nationals abroad. For example, Nigeria enacting laws to regulate citizens' behavior both within the country and abroad. Two, jurisdiction to educate. That's educative jurisdiction. The first one was prescriptive jurisdiction, the educative jurisdiction. And from the word education, this type of jurisdiction allows the state to bring individuals and entities to before its court to resolve problems and prosecute crimes. It determines the competence of a country's legal system to hear a case. A Nigerian court has the authority to adjudicate cases involving crime committed in Lagos or cases involving citizens abroad, depending on the nature of the offense. Jurisdiction to enforce. You see, refers to the authority of a state to enforce its laws or decision through administrative and legal means, such as imposing penalties, seizing assets. That's enforcement. Enforcement is generally limited to states' territory, but cannot extend abroad with international, but can sometimes extend abroad only with international cooperation. Then, example, the Nigerian government enforcing tax obligation on companies operating within its borders and extraditing offenders in collaboration with other countries. These types of jurisdiction collectively ensures that states can regulate, educate, and enforce legal matters effectively. Okay. Define and explain three elements present in defamatory offenses. Defamation, the definition of defamation. Defamation refers to a false statement made by one individual about another that damages the reputation of the latter. It can occur in two form: libel, which is defamation written in written, printed, and permanent form. Then we have slander, defamation of spoken and transient form, or transient form rather. So, three elements of defamation. First, there must be defamation. The statement must be false. The statement must be false. The statement, if the statement is true, it cannot be considered as defamatory. Falsely accusing someone of committing crime they did not commit. Two, publication. The defamatory statement must be communicated to a third party other than the person defamed. Posting a false claim rather about someone on social media. That's an example. Injury to reputation. There must be an injury to reputation. It must cause a damage. The statement must harm the reputation of the individual, causing them to be ridiculed, shunned, or lose opportunities. So these are three elements of uh, then maybe the fourth one, it must be directed at an individual. It must be directed. The fourth one here, it might be directed. What I mean by it should be directed to the individual, meaning that once a statement of defamation is made, it must be directed to somebody. There must be a second person at the end of the statement that it's directed to. So, which from the definition of defamation here, you see, defamation refers to a false statement made by one individual about another that damages the reputation of the latter. So, there must be the latter. So, even from the definition, we can get the elements of defamation. A false statement must be made, it must be directed to another, it must cause damages, and it must be published. From the two type, you see, it must be a publication. Defamation statement must be communicated to a third party other than the other. That's the publication and the so let's go on here. Write short notes on the principles of copyright and mention the act and principles of copyright and mention the acts restricted by copyright. You see, basic principles of copyright is that exclusive rights. Copyright grants creators exclusive right to reproduce and distribute, perform, and display their work. Two, originality must be original and resort to the creator's effort. Three, three, fixed medium. The work must be recorded fixed in a tangible medium like paper and digital files. Four, limited duration. Copyright lasts for a specific period of time, 70 years after the author's death in many jurisdictions. Five, it must be fair. Some uses like criticism, teaching, and newspaper reporting may not infringe copyrights. So, act restricted by copyright, reproduction of the work without permission, distribution of copies for commercial purpose, public performance of the work without authorization, making derivative works based on the original. That's making something else out of the original. These acts are not permitted by copyright. Downloading and sharing movies online without the producer's permission violates copyright law. So these four things of measure acts restricted by copyright. So reproduction is one act, distribution, public performance without authorization, making derivative works based on the original. List and explain kind of jurisdiction that exists in a matter, determining a country's jurisdiction. So we have territorial jurisdiction. based on authority based on geographic location or the event of the crime. A committed a murderer committed a murder committed in Abuja falls under the Nigerian court's jurisdiction. Personal jurisdiction, authority over an individual based on their nationality and domicile. Nigerian citizens abroad may still be subject to Nigerian law for certain offences. So that is it. Remember the case of Hush Puppy. There was a personal jurisdiction over him because he was scamming more of US people, despite he was residing in Dubai and Malaysia. You see, he was extradited to the US from Malaysia from Dubai where he was caught. So you see, universal jurisdiction applies to crime of international concern such as war or piracy. International tribunals prosecuting wars in Uganda like the Hague. So we have subject matter jurisdiction, the fourth kind of jurisdiction, authority over specific type of case based on their content and their nature. A tax dispute handled by a court specializing in tax law. Please note this that the difference between the first jurisdiction I mentioned and this second type of jurisdiction is that this is about the scope and nature, the scope and nature. This is scope, the place, the why the other one is the nature. So jurisdiction to uh, prescriptive jurisdiction, adjudicative jurisdiction for the other one, and we have lastly, lastly we have the last one, which was jurisdiction to enforce, enforcing jurisdiction, jurisdiction to enforce. Yes, jurisdiction to enforce. Both can be used interchangeably. So anyone that suits you, both should can be used interchangeably. So list and explain elements of defamation. Again, we talked about it. The statement must be false. There must be defamatory statement. It must be false. It must not be true. Because one of the elements that vitiates defamation, that cancels defamation or defenses of the defamation is truth. So you see, the statement must be false. Truthful statement cannot be defamatory. Falsely accusing someone of corruption is defamatory. Uh, Two, publication. Publication, the statement must be communicated to at least one person other than besides the victim. Besides the victim. Publication, publishing an article with false claim. That's defamation. Harm to reputation. The statement must harm the person's social and professional standing. The statement must harm the person's social and professional standing. Losing a business client due to defamatory remark. Intent and negligence. The offender must have acted intentionally, negligently in making the statement. A journalist publishing unverified, damaging information. List and explain basic principles of copyright. We talked about it. List and explain basic principles of copyright. Right to reproduce, right to distribute, right to derivative work is the same again. Right to publication, right to public performance. So one is right to reproduce, right to distribute, right to derivative, where only the owner can create adaptations and make movie based on a novel. Unauthorized sequel infringe on copyright. So right to uh, public performance. Owners can control public performance of their work, such as plays and music. Playing copyrighted music at an event without license is illegal. Now, list and explain the test to be carried out before applying exemption for exemption. List and explain the tests to be carried out before public interest test, determining whether granting exemption serves public interest. Using copyrighted uh, uh, materials for educational purpose may qualify. Proportionality test, assessing whether the exemption benefits or outweighs any harm caused to the copyright owner, allowing certain uses of copyright material for non-commercial research. Necessity test. Evaluate whether the exemption is necessary to achieve the intended purpose, using experts from copyrighted books for critical review without alternatives. So let me explain the two jurisdiction I explained here, the two types, but focus on different perspective. The first jurisdiction, the first explanation is territorial, personal, universal, and subject matter jurisdiction. You see, this explanation classifies jurisdiction based on types of authority, scope under international law. The first one was types of, so this identify fiscal and subject or subject specific domain in where a country has authority. See, territorial jurisdiction focus on events, crime, and occurring in the states and geographical boundaries. If, even in Nigeria, for territorial jurisdiction, in the southwest and other southern states, we have the criminal code. And I think in the northern part of Nigeria, we have the penal code. You see, this is about types of jurisdiction and types of laws within an a geographic area. Personal jurisdiction, you see, this uh, focus on individual, particularly nationals, regardless of their location, personal jurisdiction. Universal exerts authority to heinous crimes like privacy, genocide, and affecting global interest. That is universal jurisdiction. We have international courts in Hague. Subject matter jurisdiction refers to courts specializing in specific topic, e.g., family law, tax, and special courts. These are and tribunals, election tribunals, and the rest. The approach is broader and focused on nature and scope of authority. Second explanation, prescriptive, adjudicative, and enforcement jurisdiction. These explanation focus on the functional jurisdiction power in a country. It explains how state applies, interprets, and enforces law. So prescriptive is how it applies, the power to make laws regulating people and property conduct. Then uh, jurisdiction to adjudicate is the power to resolve dispute or crimes in a legal setting. Jurisdiction to enforce the power to implement laws or judicial decision. That's a power to enforce, like to seize, like to jurisdiction to enforce, to seize, to impose fines and others. This approach is functional and process oriented, detailing how a country exercises the legal power. So the first explanation. So you see, we have prescriptive, scope, domain, who, where the laws apply. Second explanation, functional powers, how laws are applied and enforced. Focus, types of authority, territorial, people, and crimes. This is scope and domain. This is functional. Legal process, legislate, educate, and enforce. So, um, example, crimes in a territory or global crimes. These are for territory, people, and crimes. Types of authority. Then we have application, cause jurisdiction, law enforcement. Then we have level of detail, broader classification, and this is broader and detailed procedure framework for. So they're both complementary in nature. Both classifications are valid and complement each other. The first focuses on scope and subject of jurisdiction, and the second delves into legal authority exercised in practice. Both are important to understanding country's jurisdiction comprehensively. So that's why I've done this table. So you see, the first one is scope and domain. That's the one that has territorial people and crimes. Second one is functional powers, laws that are applied and enforced, legal process, legislate, educate, and enforce. Crimes in territory or global crimes, applications, courts, jurisdiction, laws, and enforcement. Classification, broader, this was detail for procedural work. Moving down to the difficult questions, we have 8 difficult questions. We've discussed the easy questions. So move to the first difficult questions here. We have discussed the statutory and institutional framework for administration of intellectual property rights in Nigeria. The legal framework for intellectual property rights in Nigeria includes various laws designed to protect the creation of the mind, such as invention, artistic work, and industrial design. First, we start with the Copyright Act, Cap 28, Laws of the Federation of Nigeria 2004, governs the protection of literary, musical, artistic, and film, broadcast, and sound recording. Provide author with exclusive right to reproduce, distribute, adapt their work. Example, a Nigerian musician rights to their song are protected under this act. Patent and Design Act, Cap P2, Law of the Federal Republic of Nigeria 2004. You see, this is protect inventions and industrial designs, grant exclusive right to inventors to fix for fixed period, ensuring they can exploit their invention commercially. And the example, a Nigerian engineer who designs a new irrigation system can apply for patent to protect it. Trademark Act T13, Cap T13, Laws of the Federal Republic of Nigeria 2004, regulates the registration and the protection of trademarks, prevents unauthorized use of business distinctive logos, signs and logos. Example, Dangote's group logo is protected under the Act. Industrial Property Act, which is a Propriety Act of 2005, provides individuals with guidelines for patents, trade, and design. Institutional framework, which institutions help to protect these rights. So we have for copyrights, we have the Nigerian Copyright Commission (NCC), established to enforce copyright laws, combat piracy, promote copyright awareness. So example, NCC shutting down illegal film distribution networks. Two, Trademarks and Patent and Design Registry operates under the Federal Ministry of Industry, Trade and Investment, responsible for registration of trademarks, patent, and industrial design. So customs services, working to prevent importation and exportation of counterfeit goods, intercepting fake pharmaceutical products in Nigerian port courts, handle intellectual property disputes, and provide judicial interpretation of intellectual property laws. So these are institutional frameworks that help to, let's see from the question, help in the administration of intellectual property in Nigeria. So So the next question here is, the next question here is, in what ways would the emergence of digital technology impact copyright balance? Digital technology has transformed how copyrights are applied, creating new opportunities and challenges. So let's look at the positive impact. Wider distribution to create works for creative works. And technology enables authors and artists to share their work globally, reaching larger audience. Nigerian filmmakers are now using Netflix and Amazon Prime videos to share their distribute their movies. Two, efficient licensing and monitoring. It has led to efficient monitoring and licensing. Digital tools make it easier to license, trace the usage of copyrighted material. Streaming platforms like Spotify automatically calculate royalties for musicians. New revenue stream, digital platforms such as YouTube and other digital platforms provide creators with alternative income. So the negative impact: piracy and unauthorized distribution. Digital technology facilitates illegal production and sharing of copyrighted works. Example is unauthorized download of Nigerian music album on file sharing website. Difficulty in enforcing copyright. Global anonymous nature of the internet makes it harder to enforce copyright laws. Tracking down the origin of the pirated movies shared on social media could be difficult. Fair use challenges. Determination of what constitutes a fair use in digital age is more complex, especially with user-generated content. So, to address these issues, Nigeria needs to strengthen the enforcement mechanism and update the law that reflects the realities of the digital age. Um, let's move to three. Discuss the restriction of on freedom of expression and list the cases of classes of persons that enjoy privilege that cannot be compelled. Restriction of freedom of expression. One, freedom of expression is guaranteed under Section 39 of the Nigerian Constitution. Uh, Section 39 of the Nigerian Constitution, 1999, as amended. However, the right is not absolute and is subject to some restriction. Defamation laws prevent individuals from making false statements that harm others' reputation, suing a journalist for publishing unverified allegations. Uh, State security. Restrictions are imposed to protect national security, public order, and public morality. The ban on inciting speech during political protests. Hate speech. Laws prevent hate speech to incite violence and discrimination, penalizing social media posts that promotes hatred. Official of secrets. So, Secret Act prohibit disclosure of classified government information. So, classes of person that may enjoy that privilege. You see, certain individuals are protected from being compelled to disclose information under the law. Legal counsel. Lawyers cannot be forced to reveal privileged communication with their client. Religious leaders, clergymen are not compelled to disclose confession made in confidence. Journalists protected from disclosing their sources except in exceptional circumstances. Discuss the principles of disclosure under the Freedom of Information Act. Freedom of Information Act 2011 in Nigeria promotes transparency, accountability by granting citizens access to public records and information. Key principles: right to access information. Citizens have the right to access information from public institutions except for classified and sensitive data. Example: requesting government spending on spending reports on education. Proactive disclosure. Public institution must regularly publish information about their activities and finance. Exemptions. Certain information are exempt from, such as national security, trade secrets, and personal data, denying access to military strategic documents. Timely response. These institutions are required to respond to requests within 7 days, providing uh, documents within a specific or stipulated time frame. Accountability. Failure to comply with FOIA, Freedom of Information Act, can result to penalties and legal actions against the institution. Protection of whistleblowers. Protect individuals who disclose information on illegal activities within public institutions. By enforcing principles, FOI ensures transparency, promotes accountability, and strengthens democracy in Nigeria. We move to the next. A number of theories underline intellectual property protection. Uh, Examine all the theories of uh, intellectual property. Intellectual property protection is justified through various theories that explain why creators, innovators deserve exclusive rights for their work. These theories form the foundation for intellectual property law and influences the application worldwide. First theory is natural right theory. The theory posits that creators have an inherent right to own and control result of their intellectual labor. So the theory is based on philosophical idea that individuals should enjoy the benefits of their work. That's why it's a natural right theory. It is articulated by John Locke. Intellectual property, like physical property, is seen as an extension of the creator's effort and deserves protection. So going further, we should check. Uh, okay, an example is a Nigerian artist who creates a painting has the natural claim to decide how the artwork should be used, sold, exhibited without interference. Critics believe that this theory does not account for collective contribution to intellectual work, especially in collaborative industries. Incentive theory. The incentive theory argues that intellectual property rights are essential for motivating creativity and innovation. Without the promise of protection and rewards, individual organizations might lack the motivation to invest time, effort, and resources in developing new ideas and products. This theory aligns closely with economic policies that drive innovation. Example, a pharmaceutical company spends millions of dollars to develop a new drug. The exclusive right, patent right incentives such investments by ensuring that they can recoup the cost and earn profit. The exclusive patent right incentivizes such investment by ensuring that they can recoup the cost and earn profit. Significant. The theory is particularly important to industries like technology, healthcare, and others where innovation requires significant capital. That is incentive theory. We go to economic theory. So understand here the first theory we talked about was theory of natural right theory, then incentive theory, then economic theory. Economic theory focuses on economic benefits of intellectual property right, emphasizing that property protecting IP, intellectual property, encourage efficient allocation of resources and economic growth. By granting exclusive rights, IP laws create a competitive advantage for innovators, which in turn derives economic development. So Nigeria, for example, Nigerian film industry in Hollywood thrives because of the copyright laws that enable filmmakers to monetize their work, thereby contributing to the economy through creation of job and revenue exports. So the criticism over protection of IP can stifle competition and create monopolies, leading to higher cost of the consumer. Personality theory. This theory views intellectual property as an extension of the creator's personality and identity. It urges that a person's creation reflects their individuality, emotions, and experience, making it necessary to protect these works, to respect the creator's dignity and moral rights. Example, a fashion designer unique collection is not just a product, but a representation of their artistic vision, their which deserves recognition and legal protection. Relevant. This theory underpins moral rights protection, ensuring creators retain the right to be credited and prevent the misuse of their work. Authoritarian theory, utilitarian theory justifies intellectual property rights based on maximizing societal benefit. It argues that granting exclusive rights encourages creativity, innovation, and ultimately benefits society for fostering cultural, scientific, technological advancement. By granting copyright to authors, societies gain access to diverse literature and educational resource, which will enhance the cultural and intellectual growth. So social planning theory. Social planning theory. This theory emphasizes that the role of intellectual property in achieving broader societal goals. it sees intellectual property as a tool for promoting education, preserving heritage, and fostering research and development. Example, copyright laws in Nigeria traditional music is preserved and recognized as part of country's heritage. In conclusion, these theories collectively justify the existence of intellectual property law. While each theory offers a unique perspective, together they balance the rights of creators with societal needs, ensuring innovation and creativity thrives in a fair and equitable manner. Number six, discuss. Number six, discuss uh, various instances of thought-related in electronic information. The rise of digital technology has introduced new norms of thought related to economic, related to electronic information. These thoughts involve civil wrongs that harm individuals, businesses, and uh, and organizations in digital space. Defamation. Defamation is occurs when there's a false statement, they are published online, damaging reputation of individual or organization. In the context of electronic information, this often happens through social media and blogs. Example, a false claim of a Nigerian politician involvement in corruption published on Twitter can lead to reputational damage and legal action. Then uh, relevance, online defamation is more damaging due to its wide reach and rapid rapid dissemination. So invasion of privacy. Invasion of privacy involves unauthorized access to and misuse to someone's information, personal information, and private information. In the digital age, this can include hacking, unauthorized surveillance, and data breach. Let's move down. So we talked first about defamation, discussed the instance of thought in electronic this in various instances, defamation, thought, defamation. We talked about invasion of privacy. We talked about intellectual property infringement. This occurs when copyrighted. This occurs when copyrighted trademark and patent materials are used without authorization. Digital the digital environment has increased with frequency of such infringement due to easy access and duplication. Let me define thoughts. Thoughts are key areas in laws that deals with civil wrong. A thought arises when one party action or omission causes harm to another person, harm or injury to another person, and the injury, the injured party seeks compensation through lawsuit. Thoughts are distinct from criminal law as they are primarily concerned with providing remedies to victims rather than punishing offenders. There are types of thought, intentional thoughts. This happens a person intentionally commits an act. We have such as negligent, assault, false imprisonment, defamation, trespass. These are thought. Negligence again. This is thought. Duty of care, breach, causation, damage, strict liability. These are another term. Strict liability cases they can be held liable. The offender can be held liable. Dangerous animal ownership is an example where the offender can be held liable. These are thoughts. Uh, Usage of explosive or other inherent hazardous activities. Defective products, that's product liability. These are thought. Remedies to thought, compensation of damages, punitive damages, injunctions. Importance of tort law: protects rights, it ensures individuals can seek justice for personal harm and property harm, deters misconduct, compensates victims. So tort here basically is a key area of law that deals with civil wrongs. Tort arises from when one party's action or omission causes harm or injury to another party, and the injured party seeks compensation through civil lawsuits. So you see, that's why we started here when they talked about discuss various instances of thought in electronic information. One is defamation, two is invasion of privacy, three is intellectual property infringement, four is fraud in a digital space involves deceiving individuals and organizations for personal and financial gain. Common examples include phishing of emails, fake e-commerce website, a scammer creating a fake website mimicking Nigerian bank to steal user login credentials. Another thought is negligence, which I mentioned, occurs when an entity fails to take adequate measures to protect user data and prevent harm. Organization can be held liable for data breaches caused by insufficient cybersecurity measures. A social media platform failing to secure user data leading to unauthorized access by a hacker. Trespass to chattels. This involves unauthorized interference to someone's digital property such as servers and a computer system. Threats often include cyber attack, distributed denials of service. So, excuse me. Computer crime and cyber crime are similar but different. Discuss. Computer crime and cyber crime are closely related but differ in scope and focus. Both are illegal activities carried out using technology, but their definition and examples highlight key distinction. Similarities, both of them are technology dependent. They rely on computers and network to carry out these offenses. Hacking into a database can be classified both as computer crime and cyber crime. Harm to victims, both types create harm to victims. Both types result in financial, reputational, psychological harm to individuals and organizations. Legal and technical responses both require cybersecurity measures and legal framework to address effectively. The differences aspect computer crime crimes involve direct use of computer like hacking. Cybercrime involves using internet as a medium, e.g. phishing scams. That's why it's cyber. That's why this one is computer. So when you focus the scope, focus on attack on systems and network includes broader internet-based crime. So, example, installing malware to steal data, and this one cyber stalking, online harassment, and social media. Conclusion: while both involve technology, computer crimes focus more on technical attack. Cybercrime encompasses broader range of activities. Both require robust legislation and collaboration to mitigate their impact. 8. This is the last question. State and examine theories of intellectual property you know, which we've already done at the beginning. Natural rights theory, economic rights theory, we have a utilitarian theory, we have several theories. I think this is saying state and examine this. So we did it earlier on. So the question is just repeating itself. So thank you. Bye bye. Jesus Christ of Nazareth.